5 seconds to go. Start. With regard to surcharge on sales tax and turnover tax, it is submitted that taxes levied are completely outside the ambit of Section 40A 2B of the Act. It is submitted that the Kerala Surcharge on Taxes Act 1957, foreshort KST Act, is enacted only to increase the taxes inter alia on the sale or purchase of goods. As such, it is nothing but an increment to the basic sales tax levied under Section 5(1) of Kerala General Sales Tax Act 1963, foreshort KGST Act. It is submitted that surcharge on sales tax is nothing but an enhancement of tax itself. In support of the said submission, the learned counsel has placed reliance on the judgments of this court in the case of CIT versus K. Srinivasan and in the case of Sarojini Tea Company Limited versus Collector Dibrugarh. Reference is also made on the CBDT Circular number 3 of 2018 dated 11th July 2018 to buttress the said submission. Learned counsel, by drawing our attention to the distinction between fee and taxes which is maintained throughout the scheme under Section 40A, has submitted that the sales tax and turnover tax is outside the scope of Section 40A 2B of the Act. Lastly, it is submitted that for the assessment year 2014-2015, the assessing officer has allowed deductions in respect of surcharge on sales tax and turnover tax. The Commissioner interfered in exercise of power of revision under Section 263 of the Act. It is submitted that the view taken by the assessing officer was a possible view. As such, the very invocation of revisional power was not permissible to interfere with the order of the assessing officer. With the aforesaid submissions, learned counsel has submitted to allow the appeal filed by the assessee and dismiss the appeals filed by the revenue. Shri Venkata Raman, learned ASG, appearing for the revenue, by drawing our attention to the provisions under Articles 285 and 289 of the Constitution of India, has explained the intent behind the amendment to Section 40 of the Income Tax Act 1961 by Act 17 of 2013. It is submitted that in terms of Article 289 of the Constitution, the property and income of a state is exempted from union taxation. The constitutional protection under Article 289 had led the states in shifting income profits from the state government undertakings into consolidated fund of the states. It is submitted that state government undertaking KSBC, which in this case is a company like any other commercial concern, is engaged in trade and business and commercial activity, therefore, is to be treated like any other business entity. Stop.